So, how do you be fair with divvying up real estate, farmland, cabins? Hi, I'm Claire Langton-Yanowitz at the Yanowitz Law Firm, where we've been helping families protect what matters most for the last 29 years, including their cabins, farmland, and businesses. Farmland, businesses, cabins, they all pose some awkwardness in estate planning insofar as people oftentimes want to treat their children equally, but some assets can't be easily divided, such as cabins, farmland, businesses. And so when that happens, people have to get creative. And I want to talk to you about some of the creativity that goes in with these types of properties. So, first option that sometimes people have in these circumstances is to create what's called a first purchase option. So, this is for the kid that uses the cabin all the time or works on the farm, and you want to give that kid a right over that property over all their siblings. And you have two kids, and the cabin takes up 70% of your estate. So, you don't want to just give the cabin to your kid, because if you do that, they're going to get more value than the other child. Okay. So, what we do as kind of a default is called a first purchase option, where we say, well, this kid who I really want to give this cabin to, they have a first right to the cabin. They can use their 50% share to buy the cabin, and then they're going to have to come up with that extra 20%. And they're going to have to either use their own assets, or they're going to have to get a loan from a bank or something, but they're going to have to come up with that extra 20% shortfall to buy out their sibling. And so when we write these first purchase options, there's a couple of things that we need to hone into. First is, what is the purchase price going to be? Is it going to be the appraisal value? Is it going to appraisal value as of the date of death? Are we going to have it be the real estate assessed value? So those are things to consider. Then we want to really hone in on how much time does that child have to make this decision on whether they want the real estate or not. So we want to make windows where it says, after I die, the real estate is appraised, and, the trustee gives that to the beneficiary, and they have 2 months to decide in writing on whether they're going to go forward with this first purchase option. And if they don't go forward in 2 months, or they don't respond, then, the trustee can either give it to the other kid, or they can sell it, and the proceeds are split. Okay. Now, if the child does in writing decide to go forward, then the child has another 2 months to, come up with financing to close the deal. And if they don't close in the next 2 months thereafter, then the property can be sold. So creating all these time limits in it allows the estate not to go stale. Sometimes people kind of twiddle their thumbs a lot. I don't know if I want it. I'm not sure if I want it. They can't make a decision. This forces them into making a decision in a reasonable time after a parent dies, so that not everybody else is, left in this nowhere's land of, we don't know how we're going to settle the estate because so and so can't decide if they're going to take the cabin. Another option that we have drafted for clients in the past is a cabin trust, where they want the children to be able to co-own the property after they die. And oftentimes when we do that, we will put in some seed money to the cabin trust, where that seed money can be used to pay for expenses, so that kids don't have to reach into their own pocketbooks to, pay the real estate taxes, to pay the utilities, put a new roof on the house. It just depends upon what the size, what the parent wants to allocate to that, and also whether the children can afford to have a second house. Sometimes people would like to have a cabin, but they just don't have the money to cover all the carrying costs associated with having a cabin. The cabin can also delineate if a child wants to get out, they have to sell to the other kids, or, what does it take to actually sell the cabin? So it can set up rules to that effect. A cabin trust can also act as protection in the event one of the children gets divorced, is sued, or goes bankrupt in the future. It can act as protection if someone trying to take away the child's interest in the cabin from them. We will also put businesses, rental real estate, farmland in entities. So an LLC or a partnership, And sometimes we'll have the children be partners while mom and dad are alive. Sometimes they're able to vote. Sometimes they're not able to vote. And sometimes they just form this partnership after mom and dad die. Well, mom and dad gave them the farmland outright, and the children want to set up rules and agreements on how to operate this entity. And so they put it in their own partnership at that time. Now, why would you want to do this? LLCs can create protection if a child runs into getting divorced, going bankrupt, having asset protection issues. So it can act as protection from someone trying to take it away from the kid, can make it harder. Also, if something happens on that piece of property, it can make it so that it is harder for that thing that happened at that property to go outside of that property and go after the children's homes, for example. So maybe they own some rental real estate and there's some personal injury issue with the property, and so it makes it harder if that property is in an entity for that problem to bleed into these children's personal lives outside of that. With an entity, a business entity, you can also set up rules, buy-sell rules, on what will happen if certain triggering events happen. So what if a kid gets divorced? What if they die? What if they become incapacitated? Do the partners or members have to offer it to the other children before they can offer it to a third party? So rules like that. Does the entity or the partners need to carry life insurance so that they can buy each other out when and if that time comes? So you can set up agreements and rules and standards on what needs to be done. Now, if children just own real estate jointly, not in an entity, and they all want to sell it. In Minnesota, whenever you're signing a deed owned by people, all the spouses have to sign. And so if some of the children have estranged relationships with their spouses, that can be an issue, or their spouses don't agree to the sale, that can be an issue. Whereas if the real estate is owned by an entity, Business A, LLC, the individual owners don't have to sign and their spouses, just the entity needs to sign. So that's a way where the spouses are not involved with the decision of sale from the entity if you put it in an entity. If you have a business, a cabin, a farmland, we'd be happy to help you and sort out and crafting a plan that makes it fair for your family. Just give us a call, 507-252-8997. Thank you.